The Department of Justice just came down hard on Washington state. They handed the governor a 1-week deadline, just 7 days to dismantle that sanctuary legislation or face legal action, criminal prosecution, and the loss of federal funding. And here's the twist: whatever unfolds, there could be the identical strategy they deploy against Second Amendment sanctuary states. And today, I'm analyzing why a battle over immigration policy in Washington could be the alarm bell for every gun sanctuary jurisdiction across America. Stay with me, because if the DOJ succeeds here, the consequences could reach your neighborhood. Before we jump in, hit that subscribe button, ring the notification bell, press all those buttons below. You don't have to, but it keeps this operation moving and allows me to produce more of this intense firearm discussion for you. Okay, that's enough. Let's return to the topic. The DOJ ultimatum. The Department of Justice just came down hard on Washington state. 1 week, that's all. They informed the governor, eliminate that sanctuary legislation or we're pursuing you. Not eventually, not possibly. 7 days or legal action, prosecution, and federal funding disappears. That's the intensity here. This isn't some cautionary memo they can ignore. This is the Department of Justice directly stating we're finished negotiating. They're targeting Washington's Keep Washington Working Act from 2019. The legislation that explicitly instructs local law enforcement don't assist Immigration and Customs Enforcement, or ICE. No holds, no roadblocks, don't exchange data either. Federal authorities claim that's not merely incorrect, it violates federal law. And they're not halting at statements. They're threatening to pursue authorities individually. Criminal prosecution is possible. Consider that momentarily. They're not merely threatening the state collectively. They're staring directly at sheriffs, at city leaders, at anyone implementing this legislation, and warning will target you as well. Additionally, they're prepared to eliminate millions in federal funding that Washington depends upon for law enforcement. That's how you compel obedience. You restrict the funding and intimidate the authorities. And this is where the narrative shifts for us, because once the DOJ secures a victory like this, they don't conclude at immigration. They apply that identical strategy, place it directly upon Second Amendment sanctuary states, and declare, okay, you're next. What Washington's legislation actually states. Okay, so let me explain what Washington truly implemented back in 2019. They enacted this measure called the Keep Washington Working Act, and what it genuinely accomplishes is instructing local law enforcement. They cannot assist with immigration matters. That translates to no roadblocks, no holds, and not even transmitting information to ICE. The justification from the state was, look, this helps immigrant populations feel secure so people aren't afraid to contact law enforcement. I understand the concept, but here's where it violates boundaries. It's not merely the state declaring we don't wish to dedicate our resources to federal immigration enforcement. It's the state intervening and declaring you're prohibited from assisting even if you desire to. And that's why the DOJ is activated. They're indicating at this legislation and stating, observe, this isn't merely withdrawing, it's directly obstructing enforcement. And here's what you should understand. Washington didn't cease with the legislation. They pursued Adams County Sheriff Dale Wagner because he chose to collaborate with ICE regardless. The state attorney general took him to court. Consider that, taking a sheriff to court for cooperating with federal authorities. That isn't passive opposition, that's complete confrontation. That right there explains why Washington is targeted. It's the ideal scenario for the DOJ to present in court because it isn't regarding states' rights any longer. It's regarding whether a state can penalize local authorities for performing their duties. Why the DOJ claims it's unlawful. The DOJ's entire argument depends on one element: federal law, specifically 8 U.S.C. 1373. That legislation states states cannot prevent their personnel from exchanging information with federal immigration officers. Washington's 2019 Act accomplishes precisely that. It explicitly instructs local law enforcement, you don't exchange data, you don't operate roadblocks, you don't hold for ICE. That's why the DOJ is pressing aggressively from their position. Washington isn't merely withdrawing from immigration enforcement, they're constructing a barrier, and they possess a straightforward example to demonstrate to a judge. Adams County Sheriff Dale Wagner determined he would collaborate with ICE regardless. Instead of permitting him to manage affairs in his jurisdiction, the state attorney general hit him with litigation. That provided the DOJ the proof they sought. Now, they can contend Washington isn't merely allocating its resources differently, it's penalizing anyone who chooses to cooperate. That's where the legal vulnerability emerges. Once the DOJ characterizes it as obstruction, the state's stance becomes considerably weaker. Courts disapprove when local authorities get penalized for collaborating with federal agencies, and Washington essentially delivered them a test scenario. This explains why the confrontation matters. The DOJ wants that court decision in their possession because once they obtain it, they can retrieve it whenever a state attempts something comparable. Immigration merely happens to be the conflict zone currently. But the ripple consequence, that's what firearm owners must monitor. The federal pressure. The DOJ revealed their hand, and the pressure is substantial. The initial element they mentioned was that they're prepared to pursue criminal cases against state authorities who obstruct federal enforcement. That translates to this isn't merely a political dispute between Washington and D.C. Individuals could end up in court themselves, and that transforms the entire situation for anyone attempting to defend the state legislation. Then there's the financial aspect. Washington depends upon millions in federal law enforcement funding annually. Those resources cover local agencies, training equipment, and without them, jurisdictions experience hardship rapidly. The DOJ's stating those funds vanish if the state doesn't retreat, and when local agencies begin losing resources, they don't remain silent about it. Pressure emerges from within the state itself. Additionally, the DOJ has the choice to take the state to civil court. That opens a doorway to years of legal warfare, and the expenses accumulate whether Washington prevails or fails. Even defending that battle drains taxpayer funds and government attention. Combine all of that: criminal prosecution, lost funding, litigation, and you observe how the DOJ constructs pressure from every direction. They don't require all three to succeed. They merely need one solid victory, one precedent they can reference, and suddenly, every other state with a sanctuary law, whether regarding immigration or firearms, understands they're coming. That's why Washington's situation is so significant. The feds are competing for more than one state here. The state's defiance. Washington's governor isn't retreating. The moment the DOJ delivered that ultimatum, he responded forcefully, stating the entire matter is simply political intimidation. He's presenting it as though the feds are attempting to pressure the state for opposing them, and the state attorney general, Nick Brown, stands with him. Brown's position is that Washington's legislation doesn't obstruct federal enforcement. It merely states state resources won't be dedicated to civil immigration operations. But here's where it becomes complicated. Brown's the identical individual who pursued Adams County Sheriff Dale Wagner for collaborating with ICE. So, on one side, he's stating the legislation is about protecting resources. On the other side, he's penalizing local law enforcement when they choose to cooperate. That contradictory approach is precisely what the DOJ's highlighting. They can enter court and state, observe, Washington isn't merely managing its resources. They're eliminating cooperation entirely. From my viewpoint, it's a traditional confrontation. The state's leadership is entrenched, promising they'll oppose every action the DOJ takes. The DOJ is constructing its argument with examples Washington provided them, and trapped in the center are the sheriffs and local officers who must decide whether they're adhering to state directives or aligning with the feds. That tension is what makes this battle so significant, because once a court rules on it, that decision will resonate far beyond Washington's boundaries. The sheriff and his supporters. Sheriff Dale Wagner is the individual who truly gave this battle a human face. He manages Adams County, and he disregarded what the state legislation stated. He continued collaborating with ICE. To him, it wasn't regarding politics. It was regarding performing his job the way he judged appropriate, and for that, the state attorney general dragged him into court. That action ignited a movement. Now, he isn't standing isolated. He's got America First Legal supporting him, Stephen Miller's organization, and Cooper & Kirk, a prominent law firm contributing on the legal front. They're contending Washington's own legislation is unconstitutional, that the state doesn't get to penalize sheriffs for cooperating with federal authorities. And honestly, that's the type of argument that can capture a judge's attention immediately. From my perspective, Wagner's situation demonstrates precisely how profound this extends. This isn't merely state versus federal any longer. It's local authorities trapped in the center deciding who they're going to align with. And when you have sheriffs selecting federal law over state directives, that informs you there's more at risk here than merely immigration policy. Why firearm owners should take notice. When I examine what's unfolding in Washington, I don't see merely an immigration battle. I see a test scenario the DOJ wants to employ convoy for everything else ahead. Once they prevail in a case like this, they don't need to reconstruct the argument. They can retrieve it every time a state attempts to stand up with a sanctuary law, whether it's regarding immigration or firearms. And that's what firearm owners need to take notice of. States like Texas, Montana, Arizona, and Idaho enacted their own sanctuary laws. If Washington collapses here, the DOJ will possess a court-tested strategy to pursue those next. One decision spreads nationwide. The larger question is, who truly holds authority, states or the federal government? Immigration is today's battle, but it may not end there. If you're watching from a sanctuary state, pay attention. What unfolds in Washington could be heading your way sooner than expected. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.